Hello and welcome to Courts Today by LiveLaw. Let's get to today's top legal updates. The Supreme Court has flagged errors in CLAT-UG 2025 and ordered that marks be given for some answers while deleting certain questions. In a key ruling, the Supreme Court has said that PMLA accused are entitled to receive the list of materials not relied upon by the ED. The Supreme Court has issued notice in 6 appeals challenging the acquittals in the 1984 Anti-Sikh Riots cases. Shiv Sena UBT has approached the Supreme Court seeking an urgent hearing on the election symbol dispute before Maharashtra local body polls. The Supreme Court has said that long cohabitation implies mutual consent to live together, even without marriage. I am your host, Syed Amir Hussain, with your daily roundup of legal updates from across the country. For detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the very end. And don't forget to like, share and subscribe to our channel because your support means the world to us. The Supreme Court has flagged multiple mistakes in the CLAT-UG 2025 exam and directed the Consortium of National Law Universities to revise the merit list. A bench of Justices B.R. Gavai and A.G. Masih ordered that marks be awarded for some disputed questions and that others be deleted. The court expressed strong disapproval of how the consortium conducted the exam, especially considering its impact on lakhs of students. 6 specific questions 56, 77, 78, 85, 88, 115 and 116 were discussed in detail with clear directions issued for each. The court was particularly concerned with the questions that required prior legal knowledge or complicated mathematical analysis, which it said were unreasonable for school students. The court also revived a 2015 plea filed by late Professor Shamnad Basheer seeking the creation of a permanent body to conduct CLAT exams and issued notice to the Centre and Bar Council. This decision came while hearing appeals by candidates Siddhi Sandeep Lada and Aditya Singh against a Delhi High Court ruling that had ordered limited corrections. The Supreme Court has now taken wider corrective steps to ensure fairness for all students. In an important ruling on the Prevention of Money Laundering Act, the Supreme Court held that accused persons must be given a list of documents and statements collected by the Enforcement Directorate or ED during the investigation, even if the ED does not rely on them while filing the prosecution complaint. The court said this right helps the accused apply for those documents during trial or bail to prepare a proper defense. It emphasized that courts should allow such requests unless there are exceptional reasons to deny them, especially considering the reverse burden of proof under the PMLA. The judgment noted that a fair trial under Article 21 includes the right to defend and cross-examine effectively. The court also said that during bail hearings under Section 45 of PMLA, accused can seek production of unrelied documents through Section 91 CRPC. The ruling overturned a Delhi High Court judgment that said such documents need not be shared before trial. The Supreme Court stated that denying access to helpful documents on technical grounds violates the right to a fair trial. The bench included Justices Abhay S. Oak, Ehsanuddin Amanullah, and Augustine George Masih. The Supreme Court on Tuesday issued notices in 6 special leave petitions filed by the Delhi police challenging the acquittal of 14 people in connection with the 1984 Anti-Sikh Riots. A bench of Justices Abhay S. Oak and Ujjal Bhuyan asked for trial court records and fixed the matter for July 21st. These SLPs challenged Delhi High Court orders that dismissed appeals against the acquittals due to delay. The petitions were filed following recommendations from the Justice S.N. Dhingra Committee set up by the Supreme Court in 2018 to review riot cases. The committee's 2020 report found several investigations were mishandled and suggested filing appeals in certain acquittal cases. In a 2025 hearing, the court had remarked that such appeals must be filed seriously, not just as a formality. Senior advocate H.S. Phulka for the petitioner argued that past appeals were not pursued properly and pointed out flaws in the earlier prosecutions. He said several accused were discharged without trial and many cases, including those involving murder and gang rape, ended with closure reports. The court decided to hear the issue in detail rather than in parts. Shiv Sena, Uddhav Balasaheb Thackeray on Tuesday urged the Supreme Court to urgently hear its plea challenging the Election Commission's decision to recognize the Eknath Shinde-led faction as the official Shiv Sena and allot them the bow and arrow symbol. Senior advocate Kapil Sibal made the request before a bench led by Justice Suryakant, highlighting the urgency due to the court's order yesterday to hold the Maharashtra local body elections. Sibal argued that the Election Commission's decision was solely based on legislative majority, which, according to the Supreme Court's 2023 Constitution Bench judgment, cannot be the sole factor in deciding real political party. He said he would only rely on that judgment and needs just 20 minutes to argue. Justice Kant, however, indicated that the case may not be heard before the court's summer vacation. When asked why the Uddhav group couldn't contest using their current symbol, Sibal stressed that the rival group had the original symbol. Justice Kant assured that their rights would be subject to the final ruling and said the court might consider listing the matter during vacations if the urgency is justified. The Supreme Court has quashed a rape case filed against a man accused of having sex with a woman on the false promise of marriage, noting that a long-term live-in relationship indicates mutual consent. The couple had lived together for over 2 years and signed a settlement deed in November 2023 expressing love and intention to marry. However, just days later, the woman filed an FIR claiming the man had raped her on November 18th. After the Uttarakhand High Court refused to quash the case, the man approached the Supreme Court. A bench of Justices Sanjay Karol and Manoj Misra observed that there was no mention in the FIR that the physical relationship was solely based on a promise of marriage. The court said that when two adults live together for years, a presumption of voluntary consent arises. The court also highlighted that with more financially independent women today, live-in relationships are more common. Courts, therefore, should not take a rigid view in such cases. Since the relationship appeared consensual and long-term, the court ruled that continuing the case would be a misuse of legal process.